All right, peace, everyone. Welcome, members of the Moroccan Post, the Moorish Investigative Research Committee, sponsored by the Moorish Union of Sovereign Tribes and the Moroccan Post School of Government International Law. This is the first of many committee meetings. This is June 8th, 2024. We're starting at 3:10 p.m. Eastern Standard Time. Welcome. We have Amanda Siegel and Akono Sankofa Bey are the Amanda Siegel is the committee secretary. Akono Sankofa Bey is the committee assistant secretary, as posted listed on the flyer. All right. So I'm excited about this journey. I want to salute Brother King for agreeing to take up this mantle. This is something that he and I talked about in 2022. So this is not new. This is we discussed this in 2022 of his doing something of this magnitude, and we revisit this 2 months before the conference. And that he spoke on this at the conference as he was one of the keynote speakers. So I thank you for offering your experience and your knowledge to us, King. As I said to you, everybody that's on this committee are workers. We're all workers. All right. So I definitely want to thank you. I'm excited for this journey. All right. So can you take it away?
Welcome, everyone. It's your brother, Keng El Bey, the chairman of the Moorish Investigative Committee. What I would like to go over today is the topic. We're going to talk about when you first start an investigation and you're looking into things, you should answer the 5 questions: the who, what, when, where, why, and how. So this is a very important understanding when critical thinking, when you're thinking about what you're going to present and why you're presenting it, so that you can give everybody, paint a picture of a story. You're pretty much telling a story. You got your characters, you have your table of content with everything in it, showing the information, the facts, presenting this to the court to be able to identify key elements so that you can have a strong presentation when you're dealing with the courts. So now they can look at what you got and make a true determination about what you presented. So we're going to, through this committee, I will take you through this journey of litigation. It's a special type of art form that you need to understand, that you need to be able to express in a way that is going to captivate the listeners and the courts, so that you can have a profound outcome and have a favorable outcome. Now, what we got to understand, when you're dealing with civil actions or actions, and when we're dealing in criminality, and we're talking about tort, what we have to understand, based on the preponderance of evidence standard, what you're doing is you're going to leave no doubt on the table that this happened. You're going to present evidence that there is no doubt that everything that you presented is factual, and that you got standing. So your case won't be considered frivolous, and that they saying that you was rambling and that you were reaching, and it wasn't congruent, it just didn't make sense. We have to paint a picture that is precise in chronological order, a sequence of events that is going to then be able to pull the jurors in and say, yeah, this is, they we really believe this happened based on what they presented. So that no one can say that we doubt anything you're talking about. So let's go into the the information. So it is coming, everything is pulling up. I'm trying to pull up this. So when looking at this, right? When we're dealing with the basic, right, elements. So the basis of a criminal investigation, the who, what, where, the who, what, when, where, why, and how.
Hey, King, go back to the very top. Just read the very top. Go.
That's the top.
All right, section. All right. I missed. All right, there you go.
Section 1,
Yes.
the basics of criminal investigation. The who, the what, when, where, why, and how. The 5 W's and the 1 H. Identify the victims, the suspects, the nation's leader, military personnel, witnesses, and internal bodies, international bodies involved. What is the what? To determine the nature of the war crimes, because what we're talking about is these are war crimes. This is crimes. This is a crime against humanity. We're talking about denationalization, right? We're talking about genocide. We're talking about subjugation. We're talking about dehumanizing people, right? We're talking about treaty violations, right? So when did this happen? Establish the timeline of events leading up to and during the war crimes, right? So you got to paint a picture of the individuals, their ideologies, and how their policies was woven into the fabric of America today and how it's still being maintained, right? We need to understand it. Where did this happen? Identify the locations of the crimes. So we're going to talk about that this was a mass denationalization where? In the Americas, right? We're talking about where they took over territories of the Empire of Morocco and denationalized the indigenous people here, the autochthonous people here, who and stripped them of culture, stripped them of their personal identity, their personal and national sovereignty, right? We got to look at every component and then understand why, what was their motive behind these war crimes, right? The political, the ethical, territorial control that they're using today to control the resources, right? Rich and unjustly enriching themselves. They over here eating like a fat cat. You know, trillions of dollars. The people are trillions of dollars in debt, while the government is frivolously spending, frivolously using the soil, resources, contaminating the soil, the air, the water, and everything going on, while we have no power and no voice over these resources that is naturally and native to us, right? So we must understand this. So today I want to show you, so while we talk about this, I want to talk about, as we answer these questions, we must understand what is evidence. What is evidence? What is evidence? Let's go to the best evidence standard, right? We're gonna go here first, so people can understand what is evidence. The best evidence rule, right? The best evidence applies when a party wants to admit the contents of writing, recording, or photograph at trial. But when the original is not available, in the event that the original is unavailable, the party must provide a valid reason why. If the original documents is not available and the court finds the reason provided acceptable, then the party is allowed to use secondary evidence to prove the content of a document and have it admissible evidence. The best evidence rule only applies when a party seeks to prove the contents of documents sought to be admitted as evidence. The best evidence rule provides that the original documents must be provided as evidence unless the original is lost, destroyed, or otherwise unobtainable. According to the definition in the Federal Rules of Evidence, writing is letters, words, numbers, or their equivalent set down in any form. Recording and photographs are defined similarly. The best evidence rules applies when a party that offers evidence is trying to prove that the content of the writing, recording, photograph evidence, but does not apply when a party is only seeking to prove an event. See the Federal Rules of Evidence 1004, for example. A witness may testify that they provided a payment without entering a receipt for the payment into evidence. In such a case, the witness is not trying to prove what the receipt says, but simply testifying that they made a payment. Although the payment could also be proven by having the receipt as an evidence, the best evidence rule does not require the receipt to be entered. So, I want y'all to understand what they're saying. Sometimes, let's say if your house burned down, let's say you had a will, or let's say insurance, and let's say you had insurance, and you might have had one of the original copies, or you might have had the original, or you might have had a will. It burned down. So how would somebody come in and you with yourself, how would you identify what was in the will? Well, what you would do is either the author of the will with other parties can testify to what he wrote in the will, right? And if he could testify, or he could show that he took pictures of the will, or the will was some other place, right? Let's say you recorded it somewhere on the county, right? The county can give you a certified copy because it was recorded by the original, and an affidavit could attest to that fact. So you will have to understand the witnessing standard of practice as it becomes to authenticating records and dealing with witnessing.
Let's stop there, King. That's something we want them to write down. We want them to write that down. The witnessing. Say that again, King. Make sure everyone's writing that point down. The witnessing.
The witnessing it's the
So
witnessing. So when we're authenticating records, right, you need to understand like the witnessing of documents, right? So if someone's seen me write down that I wrote a will and they know that I signed it, they will have to do an affidavit attesting that they was there present, and that they seen me write out the will and can attest to those facts based on the destruction of the original record. So we need to understand the art of witnessing as it relates to the witnessing standard.
All right, there we go. The witnessing standard. There we go. Witnessing standard.
So when we understand what a lot of people think when they see, well, I got an authenticated document. All authenticated document is a witness document. It's just somebody verifying that you originally signed it. So for example, when you get a notary document that is being authenticated, the court, the county or the state, only thing they're doing is attesting that that is a true notary and authenticated that they can do or perform that duty. That's it. And when I authenticate a will, All I'm saying is that is my signature on the will. And somebody else can authenticate that that is my signature because they seen me write my signature on the will. So we need to understand the standard of practice when we're talking about witnessing. Evidence is based on witnessing, writing, testimonials, right? Photographs, and somebody authenticating that those things really exist. And that's just mean witnessing. So we need to understand how to produce evidence, how to have evidence weigh heavy, because facts weigh heavier than law. Without the facts, there's nothing, no law. You can't apply no law to a non-factual situation. Since most information is stored electronically, the original of electronical stored piece of evidence include archives, printout of information. When a party would like to enter a series of emails into evidence, they can print out the emails and use the printout as an original for satisfying the best evidence rule. In addition, it says, in addition, duplicates of writings, recordings, photographs of evidence are also admissible in court unless a genuine question is raised about the authenticity of the original, or it is unfair to admit the duplicate due to the specific circumstances. See Federal Rule 103. For instance, a party can enter a copy of a lease contract in a landlord-tenant dispute. However, if the opposing party claimed that the copy of the lease contract provided is fraudulent, the best evident rule requires that the original lease contract must be produced in such scenario. Whether a proponent has met the requirements for admitting other evidence of the content of a document is determined by the court in a jury trial. However, the jury determines the following issues: an asserted writing, recording, or photograph ever exists. Another writing, recording, or photograph produced at trial is the original. Other evidence content correctly reflect the content. So when we're looking at this, the jury, when you have a jury trial of your peers, they are the trier of facts. So they the ones that determine your fate based on the facts. Once the facts has been determined, now the judge can apply the law. That's why you have, when you got a power of attorney, someone is the attorney in fact, then you have the attorney at law. The attorney in fact is more powerful than the attorney at law because he can present particular facts on the case. He can present certain facts, not the law. He can show the facts. What the facts can be. The facts can be a written contract. The facts can be an insurance policy. The facts can be photographs of records, archives. It can be whatever. So, for example, let's say you gave me power of attorney over all your legal documents, and it was my job to keep up with all of that. I can be the attorney of fact to produce all your legal documents. So I can come to court as an attorney of fact. I would make a special appearance and come to the court and say, hey, I'm the attorney of fact. I got all the records to prove everything. Now I can argue on the grounds of the facts, and then I can have the attorney of law introduce the law that support the facts in which we were operating in accordance with, so that everybody was operating in compliance.
All right, so what we have here, so we have explaining the distinction between fact and law. Before we move forward, does anyone have any questions? Questions or comments?
Yes. Smil Moore Bay. I have a question. The
Okay.
attorney of fact and attorney at law. Can you like attorney at fact? You were saying that's anyone that come in with the evidence of facts.
Right.
So it could be anyone. It don't have to. They don't have to have what they say as a bar license or none of that. You come in and that would be what you use. What would you? That would be your title in the court as the attorney of fact.
Right. So now let's understand the subject matter and the jurisdiction based on the subject matter. So the attorney at law, he has they say a license to practice law. What do that mean? That he can only speak on the law based on the jurisdiction. He was granted the right to talk and speak on the legal lease. The attorney, in fact, was granted the right to present the facts, present the evidence, that now he can present the things based on the facts. He can now argue the contract, and he can say, like, say if I got a contract where it says that I'm identified from any liability, the attorney, in fact, can say, well, I got a contract with Keng El Bey, he's identified from any harm. So anything that he do while he was at work or whatever, he don't have any liability. Here's the insurance policy that we have under the corporation that prove that not only he don't have any liability based on this contract, that the insurance company was going to cover any damages in his name based on what we signed on the contract with the contract itself and the insurance policy, which is another contract. The law, now we don't have to worry about the law because it's already a settled matter. Now, what they're trying to do is determine who was at fault. Now I'm removed from any liability, so now nobody can come after me. So when we talk about the attorney at law, that these are the people that can only speak on the bar association, that can speak in these codes, this legal lease. They can speak on that. The attorney, in fact, that's why when you ever go to court, right? What has to happen for a prosecutor? He has to have a witness because he wasn't there. He can't speak on the facts. The only thing the prosecutor can do is speak on the law and what was presented to him through an investigative body. So you might have in the Bureau of Investigation, they present the evidence, but they might can produce the fingerprint, but the attorney wasn't there. Only thing he can do is present witnesses that can testify what they pulled up and verify through their discovery of the evidence. And then what he tried to do is now he tried to take the law and have it applied to those facts based on this, right? Based upon your intent. He tries to tie your intent based on what the other parties. So if the prosecutor has no witnesses, 9 times out of 10, the case is going to get 100% of the time it's going to be dismissed without a witness. That's why when the officer don't show up for court, they dismiss the case because the officer is going to testify to the facts on what he's seen. And then the prosecutor is going to tie the facts and the law together. That's why they have the conclusion of law separated from facts. But we'll get into that as we go down this journey, right? So you got to understand what evidence is. So now I went through this. Let me share the screen on evidence. Now let's talk about the definition of evidence in itself and its entirety. So let's look at particular definitions, right? Dealing with evidence. What is evidence?
Hold on, before you go, King, any other questions before we go on? Any other questions or comments? Other questions or comments? Any point of anything that needs to be clarified? Any questions? These are fundamental principles deal with standard of evidence. So it's important that, you know, King lay out the fundamental principles, because we cannot move forward without the fundamental principles of what constitutes evidence in law.
All right, Carl, Eli
Yes, go ahead.
Bey here. I got a question. On the attorney in fact and attorney at law, would that be given ahead of time the same way you would put in on your paperwork? Would you stipulate that you have an attorney of fact coming in and, you know, along with the attorney at law? Or could you just bring one in?
So this is how, anytime you enter the courtroom, you must give notice of how you appear. So a lot of us, we make the mistake. We'll come in and say, oh, you know, we don't even put in a notice, right? Or we'll say we're appearing pro se or sui juris, when we should be coming in with the exhibit and the evidence that we're coming in as the attorney in fact, that we're now got the contract that prove how we're going to appear. I'm not coming in as no other capacity but the attorney of fact to present the facts of this matter. So when I walk into a case, especially if you're trying to separate yourself, as a lot of people say, the straw man, what I do is I present the evidence that go with that. So I will present my attorney of fact, right, with other exhibits to prove my status when I come into the courtroom. So now the judge know how to treat me according to what I presented on the record, because they can't interfere with contracts. Do that make sense?
Yeah, you saying we come in as an attorney in fact, just for separation purposes, since you bring in the evidence.
Right. So it'll show you how to correlate everything. So now you have evidence. Now they can't presume anything about who your status is. You gave them a record that's truly reflected based on a contractual thing, right? You have a contract that say you the power of attorney, right?
Appreciate that clarification.
We're getting to other stuff, but I'm basing this on the international level now. So, you know, I'm gonna show you how to come in once you really understand the art of litigating. Through my experience, I done won a lot of cases over the years, and this is based on experience. This is not based on theory. This is based on actual experience. I deal in contracts. That's why I talk about contracts. So now we need to know, what is evidence? What is actual evidence? When we're talking to people, you have to know what is evidence. So we cannot guesstimate. This is not a guesstimation. This is either you know or you don't know, right? So evidence is any species of proof or probative matter legally presented at the trial of an issue by the act of the parties and through a medium of witness, right? Records, documents, concrete objects, etc., for the purpose of inducing belief in the minds of the court or the jury as their contention, right? So you're painting a picture for them, right? I need you to understand. In court, a lot of times I tell people this: it ain't about who always tell the truth. It's all about who tells the better story. It's about you inducing the jury to believe your story over theirs. Whose story sounds more plausible than not? When somebody got holes and gaps in their stories and it don't be congruent, it doesn't make sense. But if you have a story that has a timeline, you have all the pieces that fill in the gaps, and it flows. It's going to seem as your story makes the more sense and the most logical outcome. Do everybody understand what I just said?
It's long.
Uh,
It's long.
So when I go into court, I have my facts checked in a row. I have my memorandum of law. It's numbered. So when the judge look at my documents, he can follow. So I might have the memorandum. Then I'm going to have the affidavit in support of my memorandum of law with the exhibits. And I'm going to have a sequence of events in chronological order where he can follow line for line, and he can see the affidavit that support the line and the exhibit that support that, showing that I have a factual basis and through his observation that he can make a sound conclusion based upon what I presented to him. Do that make sense?
Absolutely.
So if a lot of times I try to tell people, when you don't have your paperwork number line, you don't have it in that particular sequence, and that's in the rules. So I find that a lot of Moors do not read the rules. So when I go to court, my stuff is very professional. I give him a professional thing where he can look at it and he can look at everything that I presented, and he don't have to fumble through my paperwork and try to make sense of what I presented to him. I have it all in chronological order, numbered, and the sequence of events with the exhibits, where he can just go through everything like a table of contents, and now he can follow everything to the letter. Now he can see, oh, he's on point. He's very sharp. Now it's more believable than not, because he can see that I'm organized in my thoughts, that I was very organized in my paperwork, and I was very concise. Most of the time, you can have a good argument, but your presentation is horrible. And you're going to lose based on how you presented your paperwork. You don't have it numbered. You don't have exhibits on your documents. You don't, when you have the corresponding to show where exhibit A match up with line 7 through 9, right? You don't have that in your affidavits in support, showing that line through 7 supports the exhibit based on everything explaining the facts in that affidavit. Showing a sequence of timelines and events, showing the findings of facts that support what you're saying. Give you an example. I'm just gonna make up one out the top of my head. Let's say you got your car fixed and they mess up and do a botch job on your car. Let's say they said you come in for one thing and then they charge you for something totally different. And then now you take it to another body shop and they say, well, they never fixed this, they never did this, or whatever. So how would you do that? You would show the paperwork. You would show where, okay, now you're arguing the application of law. You might be arguing a tort action. So what you're going to do is you might find some case law or whatever, write down the memorandum in which you're asking the court to do and support. Now you're going to have an affidavit where you took your car in on that day, and this is what they told you. And now you're going to show the exhibits that they showed you. Now you might have on the second thing where they were contradicting what they're saying, and you took your car to another place where they said they fixed certain things, and the other car auto mechanic said these pieces was never repaired, that they could show where the pieces were never pulled apart, because when they pulled them apart, Those was the original parts, and that they never changed anything out. So you got to show the timeline and show how that worked. So when you go to your memorandum of law, showing your tort action based on that they committed fraud or whatever, your application that you're saying that they unjustly enriched themselves under a tort action, that it was fraud and unjustly enrichment. So you would say, on this day, such and such committed a fraud where they lied to me based on these grounds. They never changed the part, they never use this, and they never do this, indicating the actions of fraud under the common law or under in accordance to let's say Ohio Revised Code 778 fraud. Then you will show the affidavit. Okay, I took my car in on this day to get these repairs, where they told me, they assured me that they had changed these parts out and they never did. Here's the invoice exhibit B1 that shows the invoice in which they charged me, right? And then you're gonna say, and same affidavit on line 8, that I took my car in for inspections to Auto Mechanic Plus, and Auto Mechanic Plus assured me that they never changed out the part, and that they did the original parts, the manufacturer original parts were still on the car. Here is a picture in the invoice or the statement from Auto Parts Plus verifying that they never changed it. So now the record's going to reflect. Now the judge is looking and analyzing and weighing your information in the content and what you presented to him. What is more likely to not? In civil actions, you only need to tip the scale 51 to 49%. You don't have to push it by a big margin. You just need a 2% difference, and you won your case. Do everybody understand what I just said?
Yes, Islam brother. This is a glory day here from Canada across the border here. I just have one question, and maybe you can explain this. Is there a difference when you make a special appearance in the tribunal? When you make a special appearance and you mention that you are a victim, well, the difference between a victim and a defendant. That's basically what I'd like for you to
a victim and a defendant. So let me explain this, right? When you're dealing with the rules of construction and when you're dealing with the court rules, you must understand the courtrooms. All of these courtrooms, they have definitions. You must align yourself with the action that you're doing according to the court rules. So if the courtrooms don't have victims in the courtrooms, you can't come in and say that I'm a victim. You understand? Because you're talking about legal argument. We're talking about the two parties, right? We're talking about the defendant and we're talking about the prosecutor, right? So your job is to debunk what they're trying to present. And you must understand these local rules. They have, every court within the United States you have the local rules. Those local rules are the rules of that particular court. Then you have the rules of procedure that's governed by the Supreme Court of that state. You must adhere to the rules. Most people lose on not just following the rules. They're not procedurally sound. So I find a lot of discrepancies because when a lot of people try to do things, they come from a pseudo point of law standpoint. They just inject what they believe what it is, and then the court strike it down because that don't align with the rules. So
Yes,
everything you do, you need to align with yourself with the rules. You're entering to the jurisdiction, right? So a lot of more say, well, they don't got jurisdiction. They don't got jurisdiction. I'm this and I'm that. The court, what they're going to do based on, if you don't have nothing to determine anything about your status, if you're saying that you got diplomatic status, you better have records that reflect that you're a diplomat. You better have records from corresponding institutions, international bodies, embassies that say that you're a diplomat. You better have records. They're court of records. You can't go in there. Now they're going to say you're doing some kind of fraudulent action and that you're perjuring yourself, and they're going to charge you accordingly. We have to stop using a lot of this pseudo law because a lot of us are not well studied in the verse or art of litigation. So people try to argue with me all the time, and I try not to argue with people because I understand how the rules of construction work. I didn't litigate it too much. So according to the rules, they tell you about special appearance. They tell you about all of these different things. And you have to adhere to the rules. You can't come up with your own thing and then expect the court to recognize you. A part of two parties being recognized. This is how contracts work. If I got a contract with you and you got a contract with me, we can recognize each other. But a third party who is not a party to the contract, I don't have to recognize nothing he's talking about because he's not a party to the contract. We must adhere to the rules. We must understand the procedural prowess. We must understand these standards of practice so that we can now adhere. So now we can have standing saying, hey, I followed all the rules and procedures. I did everything that you said I had to do. The court is not honoring none of that. So if the court start dishonoring that, the people involved lose their immunity because they're now operating outside a jurisdiction that is unidentifiable. Now they become personal liable. Do that make sense to everyone what I just said?
Islam.
So do we have any questions?
Yeah, I have a
Any
question.
questions or comments? Any questions or comments? All right. So
I
we're
have a
looking at
question.
the rules of the court. The rules of the court, not making believe, not Disneyland. Not talking about Disneyland, make it up as you go. Rules of the court. So if someone challenges King, if a conscious Moor challenges King, on what basis are they really challenging King? Is it really a challenge? So let's look at what is a challenge. So it has conscious Moor actually in the word in the logical sense of challenge, in the argumental sense, in the academic sense of argument. In the academic sense of argument, based on what King has told us about conscious Moors, based on the academic sense of argument, has any conscious Moors challenged King? Based on the academic sense of argument, of refuting his claims, of a refutation, based on refutation, refuting. How do you refute King? King is coming with the rules of evidence. On what basis would you refute King? That's not so. The Sky says, Dunkin' Donuts says, is that refuting King?
No.
So we have to know what's refuting, what would be refuting or quote unquote challenging. Because this is also part of understanding, what we're discussing here of what is a challenge or what's called a refutation, refuting. What is that? What does that mean? In the principles of argument, argumentation. Because conscious don't say that's not so. That's not, you're not refuting me. Don't Condona said, you're not refuting me. The sky says, that's not, you're not refuting me. All right. So we talk about the rules of evidence. And this is important because once it's important that we understand these fundamental principles. Will make it a lot easier once we get into the international law level. If we don't know this level, don't talk about the international law level. Don't even utter that. So these are fundamental principles. Once we understand these fundamental principles, the international law level, we were able to understand that because it's based on these fundamental principles. Any questions, comments?
I have a question.
Okay.
Peace. I just would like if you can explain how this apply when you want to or how do you go about handling the situation when you're in the court of no record? Like most of these district courts don't even have a record and the judge is just, be roguish.
Well, we're gonna talk about the rules of procedure and the rules of evidence. Once again, it's about creating a record. So I had a case that I was dealing with that. So what I did under the construction, they had a rule, right? You got to look at the rules. That's why I say you got to know these rules. So they have a rule for when the transcripts or record is not available. So I had to file a motion in lieu of the transcripts where I filed an affidavit of the evidence in accordance to the rule. And then I had to explain that the court is not a court of record. So I'm substituting this in lieu of a transcript in the form of an affidavit. And then what I did is I explained I was there. Then what I did is I took and got the court records to show that I was there as an exhibit, that I was present. Then I did an affidavit in support of the rule and in the affidavit, right? And then I used the affidavit of in the form of, I said the affidavit is the affidavit of evidence in lieu, right, of transcripts. And I just wrote out an affidavit as in another exhibit with the exhibit that showed that I was present by getting the journal entries of the court. So based on what I proved, they granted my motion and my exhibits and my evidence with my affidavit.
So you had to take it to another court?
Most of the time when you have a court of a non-record, a lot of those are your courts of a lot of the kangaroo courts or courts, those smaller courts, that I had to appeal to the common law court under the rules. They tell you what to do. You have to know the rules. That's why a lot of people lose. They don't know the rules. So I'm looking at the rules. The rule told me what to do. So I followed the rule to the letter and I sent the appeal to the common law court. When I got there, my case was automatically dismissed. They didn't even want to entertain from them lower courts because most of them courts ain't courts of record. They just dismissed. By the time I got there, my case was dismissed.
Hey King, would a good assignment be? Would a good assignment be for you to give us an assignment for the rules of the look up rules of evidence in the particular jurisdiction that
well, I don't want to overwhelm everybody just yet because you have to know.
All right, no problem.
Let me interject and let me go over the rules of evidence then. Let me show you something in relationship to that. So
hold on, question real quick before you move forward. So you saying that your case was dismissed in the lower court?
Yeah, I didn't have to file an appeal. I'm
saying because once the judge already violates you and then you appeal to the higher court, I'm saying how do you already been violated though?
How you doing, brother?
When okay, so I'm trying to figure out. So like let's say you like they have a lot of these little small courts, right? Like they call mayor courts, right? In my city, right? Let's say you in the mayor court. The mayor court is like a city court, like it's in a smaller city. A lot of my cases, when you get caught in one of these mayor courts, under the rules, it has to go to the common pleas court. It don't even go to the appealing court. The common pleas court take over that. This is why I say you got to know the rules according to your state. My state may be different from your state. You need to know the rules. If you're not comprehensive on the rules, then you already in trouble.
Islam. Question.
Okay.
Are you able to hear me?
I can, what you say again? Can I hear you?
Yeah, can you hear me? I'm driving. I'm sorry. It's
Yeah.
noisy where I'm at. So
Okay.
my question is a question and really just pondering. We know that we are in a colonial system of governance.
Yeah.
We know that the rules, statutes, codes, and everything else is applicable on the land right now. We know that we are challenging the colonial rulership of land, therefore bringing a team of people together to pull information as you're speaking, the material evidence, so that our claim can be made and proven based upon what we're showing. So my question is really kind of pertaining to, as we're going along in the classes, futuristically, is there or was there ever consideration of simultaneous examination? So for instance, you're discussing the rules of evidence as on the record for, whatever, circuit court of a certain region. So you're speaking in terms of the colonial covenants at this point in time. But can you simultaneous, do you think that's the consideration, a simultaneous examination of the rules of evidence, say international law, say international court? So like what do they say? Is there a way of doing it simultaneous so that we can see?
Let me answer that, King.
What the rules
Yeah,
of the
please. Yeah,
Let me answer that.
this is what let me say this before you get started, because I know you're gonna answer this well, Abdullah. First of all, we're trying to restore our mother. She's in a coma. So we in the stage of getting back into our sovereignty, right? So we don't have that yet. So the only rules right now, is their rules based on everything that we're doing. So Abdullah, go ahead, Abdullah.
Let me help. Let me do this thing. All right. So what is this committee? That's pretty much what it is. What is this committee about? What are we preparing y'all for? All right. This is King is giving us the basic principles of what is evidence in law. What is evidence? Meaning that, all right, he's giving us he's giving us arithmetic. This is arithmetic. So I'm going to use arithmetic. I'm going to make this analogous. I'm going to make the first four classes analogous to arithmetic. So he's giving us arithmetic so that we can move to algebra. Algebra is advanced arithmetic. Algebra uses numbers. Without the knowledge of arithmetic, you cannot do algebra. So King does not want to start us off. Somebody mute your phones or your devices, please. I'm just drawing an analogy here. I'm explaining this in an analogy. So if King started us off today with arithmetic, with algebra, let's say King wasn't doing any of this. He wasn't doing the rules of evidence. What is evidence that he didn't give us? We have to start you off with ground level. We're starting off with arithmetic. So King started off today with algebra. All right. Now, some of us wouldn't be able to ride with him in algebra because, some of us have experience. All right. But we don't want some of y'all. We don't want some of y'all to ride with us. We want all of y'all to ride with us. It's unfair for it to have some of y'all to ride with us. We want all of y'all to ride. So we're going to give y'all arithmetic. So King and I have discussed this. He's giving us arithmetic by giving us the basic principle of what is evidence and law. So when you understand, if you study New York State rules of the court, you can transfer that knowledge. New York State rules of the court. You can transfer that knowledge. So now when you step up to the international arena of study, you have a fundamental basics on what of rules of the court, because they have rules of the court in the international arena. So we've started you off in the international arena and you don't have a fundamental basis on what is evidence, as King is doing a great job in giving us that. When we move to the international arena of study, we have something to draw from. We have the arithmetic down. So now we're moving into algebra, from algebra to trigonometry. And so that's why he's doing this, because he wants everyone to have a solid foundational understanding.
I'm very sorry, my phone overheated. So I absolutely didn't hear anything except for what you said in the last minute. Very sorry. But nevertheless, nothing I heard except for, like I said, what you just said in the last minute. But I guess from what that last minute worth of communication is that you want to go very basic and very elementary to the rules of jurisprudence at this level where we're at. And again, I'm just not that I'm higher than a George Pine or anything like that. I'm just, within my scope is that if we're very specifically coming together and are designed to address the information, the evidence and so forth, dealing with the violation of ourselves and our international court prospects, then I would just assuming that it's just a simultaneous examination, not in and of just a colonial structure of law.
You didn't hear me though. That's why you say you didn't hear me. That's why. You didn't,
no,
so
I didn't.
All right. So tell you what. That's only because you didn't hear me.
We can talk later
so,
then.
Yeah, let's do it late. Yeah, because you didn't hear. So everything you're saying, I addressed already, and I drew an analogy. All right, because you didn't hear which is it's not your fault. The phone malfunctioned. Not yet. It's that you didn't hear me. So I just want to move forward, and we can address that later.
Sure.
Yeah, we address that later.
No problem.
Yes. All right.
Comment?
Yeah.
Yes, I just like to commend Brother Abdullah for that explanation that he gave. That was very basic. It was very elementary for all of us on all levels to understand. It's just like arithmetic. 1 + 1 is 2. And once you get the numbers, you go with the alphabets and you solve for the letter. So I think that was an excellent explanation, Brother Abdullah, and I really wanted to commend you on that, because I was wondering that same thing. you know, what was it that we're doing? And that was a beautiful explanation. And thank you as well, King.
I second that motion. I second that, sister. You're absolutely right.
So let me also make some profound
And
statements, right?
Islam, I'm sorry, 1 second before we continue on, but you are recording, and I just want to know for the record, we will be able to review this information because it is a lot to internalize. So will this recording be available as well? Like, because Sister Coca-Cola did not hear everything, as long as we can re-review the information, it should be okay.
Only to get to be, it's private. It'll be privately recorded. Yeah,
Okay.
it'll be privately recorded. You'll get the link. You'll get the link to record it.
Okay.
I mean, to listen to it. It'll be private. It won't be available to court to thousands of people. This is only.
Okay,
This
no
is
problem.
private. It's the private
That's,
session.
that's
Yeah.
fine.
Yes. So
We
yes.
can review the
Yes.
material. Okay,
It's
Islam.
being recorded right now as we speak. Yes.
Okay, Islam.
Okay, so I'm gonna pull one out of Abdullah hat. Status. So the first element of determining if a court can hear you is status. So a lot of us saying, hey, can we go to the international community? What is your status to the international community? Are you a member? Are you allowed to argue in the international community? Right? So you must check the boxes at the door when you go in by understanding the rules of construction. You can't just go jump into a venue and say, hey, you have a right to hear me. That's just like if I got a Costco, if say I want to get into Costco's, but I don't have a Costco card, I'm a member. Is they gonna allow me to come in Costco's and go shop? My status don't reflect that I'm a member. So we talk about international community, we got to check. Did we check the box? Are we a member so that we can go into that venue and be heard? No, we haven't checked that box yet. So now you trying to petition the court, they're going to say, what is your status to us? What is your status? You a non-member. Can non-members have their settlements of disputes heard here? Did you look at the rules? It's going to go back down to the rules. So we can't jump to no conclusions until we look at the rules. Do that make sense, family?
Islam.
Yes, it does. Yes, it does.
So in the United States, you already got a status. They looking at us as U.S. citizens, black, colored, and Negro, and other statuses. So based on that status, we can go in there and be heard on these arguments. So I'm just gonna show you some. So let's go to objections to magistrates' decisions. I had to do this. A party may file a written objection to the magistrate decisions within 14 days of the filing of the decision. This is a construction. This is what they call the substantive language in accordance to the rule. Did you meet the substantive language in the construction? What is going on in these rules? Did you understand what they're saying? So if they tell you, if a magistrate make a decision, you got 14 days to make a filing. Failure to do this, you waive or abandon your right. You then have to what they call file leave. And leave is now you got to ask the court, and now you got to explain. One of the elements that you can explain is called excusable neglect. Let's say you was in a car accident and you couldn't file this in a timely manner. Now you have an excuse why it showed that you was in a car accident, that you had your hearing, and when you left the hearing, you got into a car accident where you was in the hospital for 30 days. Now you can come back on a factual basis and argue that with the proof of your medical records and everything, and that's according to the rules, but you got to understand the rules. It's all about the construction of the rules. Moors keep trying to do stuff outside the rules, and it get dismissed. They ain't gonna entertain it. It's frivolous. They don't know where you reaching from. You just made up some stuff and think the court posted. No, that's not how it works. So then it says whether or not the court has adopted the decision during the 14-day period as permitted by Civil Rule D 53 D4E1, if a party timely files an objection, any other party may also file an objection not later than 10 days after the first objections are filed. So if any party filed, the other party got 10 days to file an objection. So let's say you file an objection and the other party don't. According to the rules, the other party had 10 days. Look at the substantive language. Now you can argue, hey, they're trying to say this. They never filed an objection. It says, if a party makes a timely request for findings of facts and conclusion of law, the time for filing objections begin to run when the magistrate files a decision that includes the findings of facts and conclusion of law. Specificity, I can't say this word.
Specificity
of objections. An objection to a magistrate decision shall be specific and state with particularity all grounds for the objection. They're giving you the rules. Objection to a magistrate's factual findings and transcripts or affidavits. They tell you right here, affidavits. An objection to a factual finding, whether or not specifically designated as a finding of fact under Civil Rule 53DA2, shall be supported by a transcript of all evidence submitted to the magistrate relevant to the findings, or an affidavit of the evidence. Or an affidavit if it says, or an affidavit of the evidence if a transcript is not available. Then it says, with leave of the court, alternative technology or manner of reviewing relevant evidence may be considered. The objecting party shall file a transcript or affidavit with the court within 30 days after filing the objection, unless the court extend time in writing for preparation of the transcript or other good cause. If the party files a timely objection prior to the date on which the transcript is prepared, the party may seek leave of the court to supplement the objection. This is what I follow.
I got a question.
Okay.
So what do you do in the event where you file, let's say, to the magistrate a demand, a request or something like in the form of maybe even like a court warrant, so asking for for their nationality, like even a traffic matter, or you file it. If you file that preliminarily before ever going in, but they ignore it on the record and then still set it for trial.
I'm trying to get what you're trying to do.
So, okay, we're talking about filing, right?
Right.
So I'm not sure who spoke before, but he was speaking, I guess I'm going backwards to kind of go forwards, but he was talking about in a traffic matter, and then we got on to the to filing. So what I'm asking is that if we file paperwork preceding let's say I got a person has a traffic matter, you file your paperwork before you ever go into the arraignment, asking for their nationality, license number, things like that, but they still proceed over your objections and over the paperwork, never even address the paperwork, just like it never happened.
So now you bringing an international argument into a specific traffic. We're dealing with traffic court. Improper, right. That's an improper venue. That's an issue for an international court. You're in the wrong venue trying to ask a court about nationality. They ain't gonna deal with none of that. You're in the wrong venue. You're in the wrong venue.
Right.
You got to go to the proper authorities that deal with nationalities and deal with that.
So I guess my question is then, so how would one, because we're all faced with these situations, well, maybe not us all, but many of us are faced with situations. So what's the proper way to go in? Because if it happens, then we're faced with a situation. So how do you handle that?
Let me address that, King.
Stop the jurisdiction, because once you go in, we know without the status there is no jurisdiction, I think, right? So you go in, so I go in, I say, hey, you don't have any jurisdiction because I'm here sui juris on special appearance. My name is Michael James Long, all of that. And they look at you like you're speaking Chinese and proceed over, and you've already filed, your status correction and all of these things. What do we do to move past that? Are we saying take him to the international?
I'm gonna let Abdullah.
Let me answer that. Let me answer that, King. All right. I know we got issues today. We have issues today. We got issues tomorrow. We got a court case tomorrow. We got a court case Monday. We got a court case Tuesday. We're speaking from the perspective of we got a court case on Monday or court case on Tuesday. All right. We ain't got time for a Moorish government, Abdullah. We ain't got time to file. We got a court case on Monday. So all right. So that's. I'm not saying that's where you're coming from, Michael. That's what I've heard for 30 years. All right. So those are heard for now. Monday, like now. All right. So for the past 5 years, Shim and I have been overcoming the misconceptions. We've overcome them as testament of people that's on this platform right now. We just had the conference 3 weeks ago. We're moving people past the misconceptions. Your question, Michael, does not pertain to this committee. Your question does not pertain to this committee.
You're right.
I'm going to address it though. So I'm just hear me out.
I knew that. I knew it too. I was
no. Let me hear me out. But I'm saying that we have to be. I want to first address your question does not pertain to this committee. So I want to. All right. So I want to place your question in the proper area. It's not this committee, so I'll address the question. But let me first address the purpose of this committee. What's the purpose of this committee? It's to prepare an international suit that's in joining with Moorish body politics. Yes, we're with that. This is prepare an international suit, and to do that, we need an educated body. This is why King is giving his knowledge to us and his experience. So it's also his 12 years of experience of litigation. And he's walking us through from an algebraic, arithmetic perspective, basic principle perspective on evidence. All right. So your question does not pertain to this committee, though I'll address that question. So I'm addressing the question outside of the committee. I'm addressing the question outside of the structure of the committee. I just want to be everyone hear me. Hear me? I'm going to answer this question, but hear me. I'm addressing it outside of the structure of this committee. So I don't want people to think that because I'm addressing Michael's question, it's the part of this committee. It's not. It's not. All right. His question has to be answered in the construction of Moorish government. When you're talking nationality, you're talking Moorish government, not individual. We've been conditioned by conscious Moors, and I was one of them for 25 years. to direct conscious Moors to individual processes regarding nationalization, of doing it on your own, of filing paperwork on your own, as opposed to in the construct of a Moorish government, where paperwork goes to your job from a Moorish government, not from your own home. Not you sent paperwork to your job or sent paperwork to a foreign government. All right. This is a violation of the procedure of international law. No Chinese or French or Dutch interface with a foreign government on their own. A Chinese national does not interface with a French government on his or her own. It's done through what? Their Chinese officials. So you have the ambassador, you have and we went over this yesterday, Michael. We went over this yesterday. You have your head of state, king, queen, emperor, bey, dey, caliph, emir, your head of state. You have your departments or your ministries. All right, so we're going to deal with the ministry. We're going to deal with the Ministry of Foreign Affairs. Mute your phone. Mute your devices, please. So everyone write this down, please. We have your Ministry of Foreign Affairs. In the Ministry of Foreign Affairs, you have ambassadors, consul generals, consuls, vice consuls, charge d'affaires. So these are in the Ministry of Foreign Affairs. They interface through that Ministry of Foreign Affairs is how we have what's called, write this down, nationality and diplomatic protection. Nationality and consular protection. So it is through your officials that interface with a foreign jurisdiction or foreign government. You have what's called the Vienna Convention of Consular Relations. Also, the Vienna Convention of Diplomatic Relations. So I go to the Vienna Convention of Diplomatic Relations, Vienna Convention of Consular Relations. I mean, there's rules. Remember King was talking about rules of the court? Well, there's rules. There's rules of diplomacy. There's rules of interchange with a foreign power. So what are the rules of interfacing with a foreign power? Does a citizen interface with a foreign power? Does a citizen of any country in the world interface with a foreign government? Here's my paperwork. Here's my national paperwork, or here's my paperwork. Is that the rules of diplomacy? If so, then you have to show it. You have to show me that then. Someone has to show me that Michael is what Michael's saying. You have to show me what Michael's saying correct. That he interfaced with a foreign government. Keep in mind, United States is foreign to Morocco. So now we talk about international law now. United States is foreign to Morocco. United States is in treaty with Morocco. So there's a treaty relationship that Morocco has with the United States. So what is the rules? Once again, rules of interfacing with a foreign government and or jurisdiction. So this, once again, I filed my paperwork. Not a Moorish consul. Michael didn't say Moorish consul filed paperwork. Michael said I filed paperwork. He didn't say Moorish consul. He didn't say Moorish government filed paperwork on his behalf. He said I did. That's where the problem is. It's the I. The I is where the problem is.
Islam.
All right, we have to learn this. We have to learn this. It's not going to take us long. With the people we have on this body and others who are not on here, who are part of that, who are down, of getting proper concepts. We are moving this thing along. But what the problem had been in proper concepts as what Michael was presenting. It's not Michael's fault. I blame myself. I blame myself because that's 25 years, so I'm part of that. So I cannot say I have to, if I'm going to, I cannot just blame, if I'm going to blame conscious Moors, I have to blame myself too, because I was part of that. I can never point fingers to conscious Moors without pointing fingers to myself. I will always point fingers to myself. Because for 25 years, I taught thousands of unconscious Moors what Michael was presenting. Thousands. So I was part of that. I'm responsible for that. And I'll take responsibility. But I'm making amends for it. Making amends for it. I'm part of that. So you can talk about me like a dog. I'm fine with that. But know that I'm making amends for it. You can say I'm not, you can say I'm STI stuff, whatever. And I'll be fine with that. I'm not going to be mad at you, but I'm making amends for it.
Islam,
Right?
brother.
Peace out. End on that.
Good. Perfect, Abdullah. Perfect. I want y'all to understand there are rules to construction for everything. When we start making decisions on our own, we're outside of the scope that make you personally liable for the injury that you cause to a state. Because you are making slanderous, you're promoting slander. Because you're not following the rules. And exactly what Abdullah said, the construction of government, we don't have one. So here we go. That's why we forming the committee, doing what we're doing with the community outreach. That's the whole purpose. It seems like we don't want to follow the rules. We want to regurgitate information just because somebody said we're a government. So that makes you a government. But they can't tell you nothing about the rules through the diplomatic channels, the conventions, and all the other treaties that were signed associated with how to establish government and how to be recognized. None of that matters. So we go into court as an individual and then we get spanked. We say that they're doing something wrong. No, you're not adhering to the construction of the rules. Rules are set in place for a reason. So now we can stop guessing. Abdullah painted a perfect picture. So there shouldn't be no more questions about no government, about all of these different things, because no individual can go in and represent a government without the authority of a government. You can't go in there and do that. And that's an improper venue. That's why that argument is rejected. Wrong venue. You're supposed to go to the proper venue to deal with that internationally. And then they're going to send the kite down the line to say, hey, wait a minute. Hold up. Hold up. That person you can't deal with because it's done through government relations. I hope everybody understand what Abdullah and I'm saying. What Abdullah explained. Do everybody understand that now? That concept.
Islam.
Islam.
Yes,
Islam.
The ICJ would be a different venue than the regular court system. So yes, one has to recognize the
We can't hear you. Can y'all hear him? Can y'all hear him? Can y'all hear him?
You sound a little
We-
muffled.
No,
He
he
sound
sound
muffled. Yeah,
How's
brother, this is being recorded, so we want to be able to hear you. This is so where we all can hear. We can all be so when we listen to the recording, you're heard and understood.
Okay, sorry about that. I don't know if you can hear me.
You sound very low. You sound like you're in water. You're in water.
You sound
You're in water.
muffled. You muffled,
Muffled.
brother.
Yeah.
All right, I'll just yell. Go ahead.
All right. Yes. All right.
So-
Anyone else? Go ahead, King.
So this is why I'm showing you these rules. You got to be in compliance with the rules. They call it procedurally sound. When the court rule on appeals and the Supreme Court findings, when you're dealing with everything, you must know these rules. This is why a lot of Moors are losing. Y'all not following the rules. Y'all all over the place. And then you wonder why you ain't winning your case. I stick to the rules. So let's go back. It says objecting to magistrate finding, factual findings and transcripts or affidavits. An objection to a factual finding, whether or not specifically designated as a finding of fact under Civil Rule 53D 3A2 shall be supported by a transcript of all the evidence submitted to the magistrate relevant to the findings or an affidavit of the evidence of the transcripts is not available. I adhere to the rules. It says either it's by a transcript or affidavit of the evidence. I didn't make that up. I followed the rules. And then it asks you with leave of the court. What is leave? Leave is where you ask permission. And then it says alternative technology or manner of reviewing the relevant evidence may be considered. The objecting party may file a transcript or affidavit within the court with the court within 30 days after filing an objection, unless court extend time in writing for preparation of the transcripts or other good cause. If a party filed times the objection prior to the date on which the transcripts is prepared, the party may seek leave of the court to supplement its objection. You got to understand what these words in this rule mean. So that means you have to look up this and ask questions. I stick to the rules. They just told you what to do. So if you follow the rules, you should be procedurally sound. Now the court going to have to justify. And if they outside of the construction of the rules, then they could be liable for violating your due process rights. Am I making sense?
Point of interest.
Okay.
In court, I know it's a lot of rules. So how do you determine which rule are you to follow, and how do you go by choosing the rules according to your issues?
Okay. So if you in traffic court, what do you follow? Asking the question. If you're in traffic court, what do you follow?
Traffic court rules.
Okay. If you dealing with a crime, what rules do you follow?
Criminal.
Okay. If you dealing in civil matters, what rules do you follow?
Civil.
Civil rules of procedure. Let's make this make sense, family.
Mm-hmm. Now, under each one of those rules, the criminal, traffic, so even the rules under the criminal court is certain rules to follow. So let's say I had a criminal case, so I follow the rule of evidence, the rule of court procedures under that criminal, right?
Right.
Okay, that's all. I just want to make that clear.
So you got to know the local rules of that court, right? Then you got to know the rules of evidence that's applicable. And if it's a criminal or civil matter, you must know the rules. Now in Ohio, they also got the rules of superintendent. In your state, they may be called something different. You got to know these rules, because all of these rules can be applied. So let me show you in a criminal case how the civil rules can be applied. So I'm just gonna give y'all just some food for thought. That's why I say you got to know these rules. You got to read these rules. You got to know all of the rules. I tell everybody, don't go in there half-assed. Know the rules. Know all the rules. I try to study all the rules. So under this rule, right, let me show you something.
What document is that you just pulled up, brother?
This is Ohio Rules of Criminal Procedure. So
There we go.
I'm just going to show you one of the rules under this rule. Now look at this rule. This is Rule 57. Rule 57 says rules of the court, procedures not otherwise specified. Why do I bring this up? Because I do this all the time in Ohio. Rules of the court. The expression of rules of the court as used in these rules mean a rule promulgated by the Supreme Court or a rule concerning local practice adopted by another court that is not inconsistent with the rules promulgated by the Supreme Court and is filed with the Supreme Court. This letting you know that the Supreme Court control these rules. This is why I talk about due process, jurisdiction. So local rules shall be adopted only after the court gives appropriate notice and an opportunity for comment. If the court determines that there is an immediate need for a rule, the court may adopt the rule without prior notice and an opportunity for comment, but promptly shall afford notice and opportunity for comment. So the court can adopt a rule from another jurisdiction, but they got to give you the right to comment. And they got to give you notice. They don't have to give you at first, but at some point they do. You got to know these rules. You got to understand what they do. The court got to follow the rules, just like you got to follow the rules. If nobody playing by the rules, then you got tyranny. This is why the rules is in place. This is why they got rules for war. If two countries in war, they got rules for that. You can't go out around killing innocent people and civilians. That's not a part of the rules. If you look at the international body for war, they tell you what you can do. This is why we got to adhere to the rules. We got to stop practicing this pseudo law. Procedures not otherwise specified. Now, why am I saying this? If no procedure is specifically prescribed by rule, the court may proceed in any lawful manner, not inconsistent with the rules of criminal procedure. Now they say they can proceed in any lawful manner, right? And shall look to the rules of civil procedure to the applicable law if no rules of criminal procedure exist. So what do I like to do? I like to do interrogatories and admissions, because under this rule, it say I can look to the civil rules and I can use civil procedures when there's no rule for the civil rule. So I like to use this rule in conjunction, right, for doing discovery under constitutional matters. So I like to bring the Constitution into play in certain matters and bring this under this rule. But it's a particular skill that I got through experience to do this. I've been litigating a long time. Most people don't got an eye for a lot of stuff that I can see, hear, and do, because I got the experience. So it's telling you that you can use the civil rules. It says, shall look to the rules of civil procedure. So understanding this rule, so I would do a form of discovery in the form of interrogatories and admissions, and have the witness or the complainant answer certain questions on the constitutional grounds to get my case dismissed. I win on this a lot, but you got to know what you're doing. And this all in the constructions of the rules. Am I making sense to y'all?
Islam.
Islam.
This is not a guessing game, family. We're not guessing. You either know this stuff or you don't. I don't go into the court and start guessing. I know these rules. I know how to file writs. If I'm use a writ, there are rules for using a writ of mandamus, a writ of habeas corpus. There's a writ of prohibition, a writ for quo retro. There are rules. You got to follow the rules. And if you don't follow the rules, then you're going to automatically disqualify your petition, because it's not adherence to the rules. They're going to say this is frivolous. We don't know what you're talking about. You are reaching. You are outside of the construction language of the rules, and we don't know what you're saying. Am I making that clear to y'all?
Yes.
Islam.
So when for this committee, we're going to find out and understand what is rules. So let's get back into evidence, because I got away from that. So I'm going to stop sharing. I'm going to go switch back over to evidence. So.
But let me say this, Ken, before you move on. Because this was good. I'm glad you did this, because this you explained so well through showing the importance of our learning the rules. So you got away, but you were not away, because you use this to show why you're doing what you're doing. Why do we need to understand what evidence is? Why do we need to understand the rules of the court? So you gave us examples, of rules of the court and the direction that you're taking us. So this is good. So this knowledge base will help us when we get to the international level. But I said we need the arithmetic step. And I appreciate you. Thank you for that.
You're welcome, brother. I appreciate you, because without them understanding this, now we can afford to kill all the misconceptions. I thank you and Shem, Amanda, Brother Kono, and all the other brother Quasi, everybody who's joining in on this meeting. I thank y'all for appearing and listening. So now we have the construction that we needed. Now we can follow the guidelines. Now they can stop looking at us and saying that we're sovereign citizens, and stop putting titles and labeling us on in court and getting us locked up for mental evaluations, because they saying y'all sound crazy. I don't have that problem when I go to the court. Court ain't locking me up for a mental evaluation because they thinking I'm crazy because I'm talking out the side of my neck. They like, what is he talking about? 30 days mental evaluation on a traffic ticket. Because you don't understand this stuff, these construction of the rules, because we're being academically lazy. We got to stop listening to people. I do this. I did this for a living, and I got good at it. So we get back to evidence. I need y'all to understand what evidence is. It says any species of proof or probative matter legally presented at the trial of an issue by the act of the parties and through the medium of witness, records, documents, concrete objects, etc. What did they just say? The legal presentment at trial of an issue by the act of a party through a medium. What is the medium? A pass-through by witness, first-hand testimony saying that they saw it or whatever. The records that reflect the true essence of what's done, contracts, documents, contracts, concrete objects. If you had a car accident and you took pictures of your car and you show how your car looked, documentation. We need to stop playing this guessing game and we need to understand these rules. So let's look at what they're talking about. I think, what is proof? What is proof? Proof of the evidence, the establishment of a fact by evidence. I told you facts weigh heavier than law. Don't have no facts, can't apply no law. What are the facts? Also, can law be facts? Yes, they can. So, for example, I'm showing you the rule. The fact of the matter, if a judge didn't follow the rule, then he in violation. I can present the law as a fact. He's supposed to do what? Follow these rules. He's outside, Your Honor. I'm filing an appeal because the court is outside. The judge is to consider the court. He ain't following none of these rules. He violated my due process right. They gonna look at the construction, the substantive language, and look and say, well, dang, he right. The judge didn't follow the rule. This is where the common law also step in. Where the common law say you have a right to be heard, right to present evidence, the right to inspect evidence, the right to call witnesses, right? The right to object, a right to an appeal. These are all common law. This is decided in the precedence of a case. This is what they call the case law, the common law. These are now, based on the construction of the Constitution, now you got common law matters in case law saying, hey, I ain't get an opportunity to be heard. The judge didn't allow me to present evidence. He didn't allow me to call witnesses. He was obstructing justice. When you know what you're doing, you stop. It's not a guessing game no more. So let's look at, let's say, probative evidence. In law, in the law of evidence, having the effect of proof, tending to prove or actual proving, testimony carrying quality of proof and having fitness to induce conviction of truth, consistent of facts and reason, cooperating as a ordinate factors. So we talk about probative evidence. When we talk about probate court, we're talking about probative terms. So in my course, I'm teaching estate planning. I talk about having a will. I talk about a living trust. I talk about estate planning. Why am I talking about? We're talking about contracts, contract law. We're talking about presenting facts and rights about contracts. Can't nobody force you to do anything you don't want to do out in a contract. That is called involuntary servitude. That's slavery. But I'm just showing you what is evidence. Where am I pulling this from? Let's go to probative facts. In law of evidence, facts which actually have effect of proving facts sought. Evidentiary facts. Matters of evidence required to prove ultimate facts. matters of evidence required to prove ultimate facts. Let's continue. Fact, a thing done, an action performed. Hold on. A fact is a thing done, an action performed, or an incident transpiring, an event or circumstance. These are facts. An actual occurrence, an actual happening in time, space, or, hold on. Why is it? It says an actual happening in time, space, or event, mental or physical, that which have taken place. It says an event, mental. An event, mental. What is they talking about? Mens rea, premeditated murder. You thought about killing a woman and you act on it. You thought about killing a man and you act on it. It was in your mind. You told your best friend you was gonna kill the guy if he come up here saying something, and you got up and killed him. That's premeditated. It was already in your mind. We got to understand what is evidence, what is facts, and how evidence correlates to facts that which have taken place. A fact is either a state of things that is an existence, or a motion that is an event. The quality of being actual existence or occurrence. I'm just showing y'all what is a fact so you can understand the rules of evidence when we start looking at these constructions of these rules. You got to understand the rules. You got to study the rules day in and day out. Testimony. Evidence given by a competent witness under oath or affirmation, as distinguished from evidence derived from writings and other sources. Testimony is a particular kind of evidence that comes from a tribunal through live witness speaking under oath or affirmation in presence of a tribunal, judicial or quasi-judicial. In common parlance, testimony and evidence are synonymous. I want you to hear that again. In common parlance, testimony and evidence are synonymous. Testimony properly means only such evidence as is delivered by a witness on the trial of a cause, either orally or in the form of an affidavit or deposition. So all you Moors who like to file affidavits in the court, if you're not filing certain writs or motions to apply the law with the fact, you out of order. You cannot do that. You can't just file an affidavit and ask the court to do something. They're going to look at you and they're going to say, I don't know what you're talking about. I'm telling you what this, they telling you the rules. Follow the rules. Is there any questions on this?
We've gone almost 2 hours, 1 hour and 45 minutes. Any questions, comments? We want to, we don't want to, so we want to end shortly because so it's a lot. It's a lot, so
I don't want to.
This will be, recording will be available. So we want to definitely, the next committee session will be June 22nd. I will be vending. I will be in Somerset, New Jersey. I'll be speaking to Unconscious Moorish Shriners Convention on June 22nd. Right, but I will be available because I'll be speaking in the morning and I'll be vending in the afternoon.
No, so everybody got this information, no questions. So everybody gonna walk away with knowing this information. You ain't got nobody with no questions.
I have a
We gotta ask, we
Well,
gotta ask questions.
I have a
yes,
question.
No,
yes.
All right, it's my serious hell. My question is, in dealing with status, so those of us Moors who were, let's say, going to these courts, operating in so-called impropria personas and juris, pro se, all of these are actually the wrong way to go into these courts. Am I correct?
Well,
Let me,
so go ahead and answer that, Abdullah.
yeah, let me, all right, all right. I answer that based on treaty. Have to look, to answer your question, we have to look to the treaty. All right, so let's go to the treaty. On the, for the past month, I've been posting the what I did by hand, and I had Conal put it in graphic format. This chart that I did, at the top it reads, does United States courts, does Article 3, Section 2 of the United States Constitution extend to Moorish cases? On the left side, I have at the top the recovery of lost Moorish sovereignty and Moorish treaties that have compensatory / extraterritoriality / extraterritorial consular jurisdiction. That is the November 25th, 1491 Treaty of Granada. That is the 1786 Treaty of Peace and Friendship between His Pure Majesty, Emperor Morocco, and the United States. That is the 1796 treaty between the Bey of Tripoli and the United States. That's the 1796-7 treaty between the Dey of Algiers and the United States. That's the 1856 treaty between the general treaty between Great Britain and Morocco. On the right side, I have Article 3, Section 2 of the United States Constitution. All right, their treaty, Article 3, Section 2 of the United States Constitution does extend to treaty cases that do not have extraterritoriality clauses. That is the Howenstein versus Lynham. Howenstein versus Lynham, that's 1879. That is adjudicated based off the Article 5 of the treaty between the Swiss Confederation and the United States. I have Ware versus Hilton, since 1796. That is adjudicated based off the 1783 treaty between Great Britain and the United States. I have Society versus New Haven. That is adjudicated based off the 1843 case, adjudicated based off the 1783 treaty between Great Britain and the United States. Those treaties do not have extraterritoriality clauses. So let's look to the treaty. All right. We're not gonna look to the sky to answer my serious question. You don't look to the sky. You have to have a basis to answer my serious question.
Point of interest, brother, before you move forward, can you explain what extraterritorial jurisdiction is for everyone?
All right.
For
So
clarity.
let's look at the word. Let's break the word down. All right. So we have the prefix extra. Extra means outside. Outside, territory, land or earth. Land or earth. So let's look at the prefix outside. Outside of land. All right. Outside of territory. All right. In this case, for us, it's not outside our land. So you're looking at jurisdiction. So we're looking at foreign. Foreign does not mean distance. Anyone who knows international law, the general public doesn't know this. The general public has been groomed to foreign being distance. When somebody off the street, they hear foreign, they automatically, because they're not schooled in international law, so I don't expect them to know this. Foreign and law means jurisdiction. Jurisdiction. So we're foreign to the United States. We belong to the Moroccan Empire by nationality, by national origin, and descent. I know our mother's in the hospital. I know she is, but that's still our mother. I know our mother's been in a coma in the hospital for 20 years. However, that is still our mother. We still belong to her. So as her children, we have to go to the hospital. That's the Shimalakai Bay plan. Going to the hospital, all right? That is the recovery of lost Moorish sovereignty. So going to the hospital and waking our mother up out of a coma, a prolonged state of the absence. A coma is a prolonged state of unconsciousness. Translate that to international law language, Abdullah. That is called a temporary collapse, dismemberment, disintegration of a state, a prolonged absence from the family of nations. So that is our condition. So we have to wake our mother up. So we look to the treaty to answer our serious question. Article 20 to 25 of the 1786 treaty between Morocco and the United States. What does that read? Come on, give it to me. Answer our serious question. You answer our serious question by going to the language in the treaty. That's the only way. The only way. No one in the world can answer our serious question without going to the language of crazy. No one in the world can answer our serious question without going to the language in the treaty. You can't look to the sky. You can't look to your hand. You can't look to the wall. I can't go inside the Dunkin' Donuts. There's only one way to answer one way, not two ways. Only one way to answer our serious question is by going to the language in the treaty. Not making stuff up. Go to the language. So you answer our serious question, y'all. What does the language in the treaty read? He says, we've been doing it wrong. He's asking what we've been doing wrong. So answer our serious question by going to the language in the treaty. What does the treaty read, y'all? What does the language in the treaty read? If a Moor shall what? Kill or wound, what does it read?
Should be tried in he should be tried in the jurisdiction of where the crime happened. I think something.
All right, so a Moorish consul would have jurisdiction. If a Moor is a defendant in the 1856 treaty between Morocco and United States and Great Britain, if a Moor is a defendant, is a subject of Great Britain, is a defendant, what does it read? The Moorish government would have jurisdiction. In the treaty between the Dey of Algiers and the United States, only the Dey would have jurisdiction. In the treaty between the Bey of Tunis and the United States, the Bey would have jurisdiction. The language is the language. Now, don't make it up. Don't cook it up. Look it up.
Look it up.
Don't cook it up. Look it up.
Look it up.
It's you don't need to say Abdullah said. You don't need to say Abdullah said. No. Why? Why do you need to say Abdullah said?
Right.
Abdullah pointed you to the treaties. Go to the language in the treaty, and then quote the treaty, the language in the treaty. That's all. That's how you answer our serious question. I'm my brothers and sisters. I'm kissing this. Just kiss this. It's not all that. It appears to be all that because you've been groomed into misconception, and I take responsibility for that. Because you've been groomed, all right, it's not complicated. It's the misconceptions. Let me help y'all. When I talk, or Shim talks, Shim speaks, you're measuring what we're saying by the misconceptions that you were groomed into. But if you were never groomed into misconceptions, you get it like this. It's the misconceptions. If we were never groomed into the misconceptions, you get it like that. So you gotta try to fit what Shim is saying, what I'm saying, what King is saying in the misconceptions. You know, so-and-so said this, you know, I've been doing it this way. And so you're trying to measure, trying to fit what we're saying into your misconceptions. That's what you're doing. That's all. That's it.
Once again, proving the point, there are rules. A treaty is a set of constructive rules. There are rules. We must follow rules. That's the problem. Once again, we go into the court and then we got to ask ourselves, did we erect our mother from the hospital yet? Is our mother still in a coma? This is why we're doing the community outreach, so that we can resurrect our mama out of the coma, to present her back and put her back in the international family.
Hey, sidebar, sorry, but we've been on for a while, but I do have an estate issue I'd like to talk about, but I know it's outside of the realm of this conversation.
Don't
so
do it. Don't do it, Michael. Don't do it. All right, let's move on. Don't do it. All right, go ahead, Mike.
So
stay within the realm of this committee. Stay within the realm of this committee.
So the purpose of this is understanding there's rules of constructions. There's rules. We must adhere to the rules, or they're going to say they are talking frivolous. Who are these people? They're not following international standards of practice. They're not following the rules. So automatically they're going to dismiss you. They're going to dismiss it and say it's frivolous. It has no basis in law. They have no standing. So we're not going to entertain this. Move on to the next. Next. And then when you go into court and you being charged and you start talking to that, find him guilty. Give him 30 days for a mental evaluation. Next. This is the problem. Abdullah is showing you, reach to the treaty, understand what's going on. Now you don't have to guess. Now we can understand, is our mother awoken, and is she a part of the international community? Some of these questions are very easy to answer if you look to the rules, and you look to the treaties, and you apply by the rules. This is simple. When you make up these misconceptions, start practicing pseudo law, it makes everything confusing. Do everybody understand what our points of view?
And it's going to take some time, King. I mean, so I don't expect, because I've been teaching for so long, that I don't expect everyone to totally grasp everything you're saying in one session. So it's recorded. It may take us a couple months, which is fine. You're not slow. You're not stupid. You're not ignorant. You're not dumb. You're none of that. All right. So this is why we're taking our time. It's being recorded. We'll do a 30-minute review on the 22nd. Move on. All right. So we're going to take moves. So before we break up into committees, we're doing education first. All right.
All right.
So I'll get a chance to look at this, take notes. I'll talk to King about this and how then we can refine with everything. So so that way we'll be prepared. All right. So I don't expect everyone, so I'm not going to ask because I know that it's going to take some time, but this giving us proper guidance. I do suggest that y'all do listen to the recording and continue taking more notes. Also write your questions down. Get a notebook, not a sheet of paper. Not a sheet of paper. I can only suggest a composition notebook, not one of those tear out, spiral bound and papers missing and all that. I'm only suggesting, because the composition books are sold in with the strong thread. All right, get notebooks, take notes. So I do suggest that y'all listen to the recording and take notes before the next session. And then write your questions down. But just be patient. You're not going to get this in no one session. You got to put the time in too in the study. Because I think that this is my experience. I will speak to my experience. That, you know, we think that we sometimes we put in practical expectations at this. I'm gonna get this in one session. It's impractical. Just be patient with us. We got y'all. I mean, we're putting our time in. This man right here, King, is putting his time in. He's putting his time in and preparing these lessons for us. He's putting his time in. I'm putting my time in. All right, we're here. Terrence is here. He's putting his time in. We're making the platform available to y'all. We're putting our time in. We're putting our time in. We will do what we would do the work and put our time in. What say ye? What say y'all about y'all putting your time in and studying? We're gonna do that. All right. So we're gonna end, everyone. We've gone an hour and 2 hours and 20 minutes. So we don't need to belabor the point. Well, thank you for I did snap shoot everyone, and we'll have the written out attendance. All right, have the snapshot of everyone that's on here. For the future, y'all, this is for future. All right, no Samsung, whatever. You must put your name in. No Samsung, no iPhone name. That's unless that's your name. It's Samsung SM S928U. That's your name. We need your name. When you come on to YouTube, type your name in. All right. So, all right.
Also,
tell you what. If your name's not typed in, I'm saying this right now. If your name's not typed in, I'm going to ask Terrence to kick y'all off. If your name's not typed in, we do this. See this right here, Samsung, whatever. Do you see that? Oh, that was June 22nd. We see that on June 22nd. You're getting kicked off.
That's usually people that dial in from their phone.
But we need their names.
It doesn't give you an option when you dial in from your phone.
Man.
Yeah, you
Is
can
there a
switch
way
it. I just changed mine. I just
Well,
changed
what I-
mine.
what I-
Mine
what I
to
can-
order. The
Yeah,
microphone's back.
Well, help me out, y'all, then, because help me out.
What
And
I
just wanna
can
be-
do,
wanna be fair.
if you can hear me,
Don't get me on.
what I can do is we can ask their names and then I can change it from my end.
Kenneth L. Bey.
All right. So also this recording, we're going to put this on a YouTube, but it's going to be unlisted. So I will ask that no one share the link that you will get, because it's only going to be for everyone who has the link. Please don't share the link unless you ask Abdullah or King, Brother King. So this will be for your viewing anytime that you want. So after this session and the video is done being prepared, then I will upload it.
All right. So thank you, everyone. This concludes the first session. This concludes our first committee session. This concludes the Moroccan, Moorish Investigative and Research Committee, sponsored by the Moorish United United Tribes of Moorish. What is it, King?
The Moorish.
Sponsored
Moorish Union of Sovereign Tribes.
Moorish Union, Sovereign Tribes, and the Moroccan Post School of Government and International Law. So this concludes January 8th, 2024, first session. We'll see y'all at 3 p.m. Eastern Standard Time on June 22nd. All right, peace, everyone.
Peace and love, everyone.
Hey, much appreciated. Peace.
Islam.
Islam.
Islam. Peace and love.
End the recording.
I'm ending it right now. This is hidden.